Now that we've covered People versus Hall, I want us to examine Conrad versus Commonwealth in a more focused manner. Interestingly, this case occurred around the same time as Hall, and it also involved everyday behavior resulting in an unintentional death. Here, it involved a common occurrence of someone falling asleep at the wheel. Sadly, this was so close to home when the accident occurred. So let me ask all of you, have you ever felt exhausted as you were driving? Maybe like defendant, you've even nodded off and caught yourself? What do you do when you feel so tired? I always ask my students this question. Maybe you roll down the windows to catch the cold air, or you sing to yourself loudly in the car. Maybe you call someone up and say, "Talk to me, keep me awake while I'm driving." Some people chew gum or eat food. I'm here to report that very few people ever say that they pull over and sleep until they're rested enough. Most of us push on. And if we're really close to home, guess what? We really push on. That's what happened here with Conrad. So first, let's get our definition of involuntary manslaughter out of the way. It's the intentional killing of another without malice and with gross negligence. It's where defendant knew or should have appreciated a substantial and unjustifiable risk of death or serious bodily harm when he engaged in that behavior. The court here does a great job of pointing out generally the three kinds of categories of unintentional behavior. As we've already seen, ordinary negligence, which for our purposes is the providence of tort law. Gross negligence, or what some call criminal negligence, which is the purview of involuntary manslaughter. And then willful and wanton behavior, which we call depraved heart, is murder too. This case is about category number 2, gross or criminal negligence. What's interesting here is that unintentional deaths that occur from falling asleep at the wheel, where alcohol or drugs are not involved, are generally treated as ordinary negligence in tort law. So why involuntary manslaughter here? Why this case? Why was Conrad the poster child for proving this forward? Let's isolate the facts here that prove to be sufficient for gross negligence. That's behavior where defendant knows or should have appreciated the substantial and unjustifiable risk. So let's start with Conrad's day before the car crash. There he is, he worked his shift at a store, he ran errands, and then he stayed up all night at his friend's home, practicing with the band and watching television. By the time he got into his car the next morning, not having slept all night, he admitted he was sleepy. And then he admitted, at least to the officer on the scene, that he nodded off 4 to 5 times before he crashed into the jogger by the side of the road. Why is this particular fact, nodding off 4 to 5 times, important under our definition of involuntary manslaughter? It's important because nodding off 4 to 5 times infers that Conrad knew, or minimally he should have known, the risk that he was imposing on those on the road with him. He knew he was so tired, incredibly tired, and nodding off several times is exactly the type of behavior that demonstrates the substantial risk that he could kill someone. The court makes a distinction between Conrad's having nodded off 4 to 5 times and another case inside our case, Hargrove, where a defendant had not nodded off before striking his pedestrian. At least that was his testimony. The court here says that Conrad should have had greater awareness of the risk he was creating than Hargrove because Conrad had nodded off previously. He knew how dangerous his behavior was. Let me take you into that scene. There's Conrad nodding off 4 to 5 times and then falling asleep at the wheel. I want you to think of them as slightly separate occurrences. With each time that Conrad nods off and then he gets himself up, he increases his awareness that he's creating a substantial risk to others around him.